Right. Hey, everybody. Adam Rossen here, and this is part 3 of our CLE. This part, we're going to talk really about the basics of the standard field sobriety exercises and some of the science behind DUI. Specifically, we'll be talking about breath tests. We'll be talking about blood tests, and we'll be talking about urine tests after we go into a little bit more detail first about the field sobriety exercises. So hopefully, the folks of you that are listening live and the ones that eventually watch the replay are getting a lot of great information out of this. Please drop questions in the chat or the Q&A. I want to make sure that everybody here gets all their questions answered, and we really are hoping you guys are loving this, and we're providing good value, for beginner level DUI cases. So the first thing I'm going to talk about, some parts that Manny already talked about, but in a little more detail, and I'm going to talk also some parts that Mehdi just talked about in a little more detail as well, from not so much of a case law perspective. So these standard field sobriety exercises, the SFSEs, what are they? Right? These mythical things. Well, they're exercises. They're not tests. And there is physical skill and dexterity involved. So that's something that I think is key for everybody to remember. These exercises, it's balance, it's coordination. And as you see, one of the common themes that we tend to discuss in front of, especially in front of juries, and the way that, I'm going to talk to you folks about this today, is really how to set this up for arguments at a deposition, at a DMV formal review, aka the bar hearing, or a trial, which I know David will then bring home when I'm done in the 4th hour of our lecture. But these field sobriety exercises, they're done to establish probable cause, not guilt beyond a reasonable doubt. And that's one of the themes that I like to take in some of my trial work as well on these cases, is making sure that the jury understand that the burden and the decision to arrest somebody at the side of the road for DUI, as Mehdi talked about, is probable cause. It's not guilt beyond a reasonable doubt. Now, what are they? Well, they're divided attention tasks designed to measure someone's quote unquote normal faculties. The problem is that they're abnormal exercises to measure the way you normally do something, or the way our clients normally do something, right? So logically, that doesn't really make a whole lot of sense. Some police officers will even try to say that they're not abnormal, which, when we question these police officers, personally, I don't care what they say, because they're either going to admit that they're abnormal, or they're going to try to dig their feet in the ground, and say, no, they're not abnormal, they're perfectly normal. And then they're going to lose credibility and look like an idiot in front of the jury. So here are some questions during cross-examination that you can ask, and when I say cross-examination, it can be at a deposition, it can be at a Bureau of Administrative Review hearing. And of course, these ones that I put here, they're not the traditional hard leading question. You can always make it a hard leading question, but I wanted it just to be the basic question for you guys here today. And again, this is even good, as Manny was discussing, if you don't get depositions in your jurisdiction, but you have that formal review hearing at the DMV, right? You want to ask these police officers what they think, because you want to know what they're going to say, right? And these are just some of the few things, example, the walk and turn, right? No, we know people don't walk like this, heel to toe. We know they don't turn with a series of small steps the way that they do with their left foot planted on the ground. We know that somebody doesn't normally put up 1 foot 6 inches in the air with their arms by their side balancing on that remaining foot. But you want to lock them in as early as possible, just so have a better idea of, hey, is this police officer, am I going to need to really cross him hard, and is he going to lose credibility with the jury, or is this police officer going to give me the concessions that I need? Now, normal faculties are actually defined by the law, Okay, it's in the statutes. And it's defined, right? It includes but not limited to the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general to normally perform the many mental and physical tasks of our daily lives. The problem with these is that they confuse average with normal. Okay. For everybody here that's on this webinar and the 4 lawyers that are doing this, if you take us all, you slice us, take us all, combine us, slice us up in half, right, or divide us by the number, you would get an average. But that average is not what any one of us is. The way, right, that's not how we talk, how we walk, how we judge distances or act in emergencies. And that's one of the big issues with this, is that the police officers, they confuse average with normal. So you got to understand that, and that's one of our one of my great themes in these cases. And it's not a pass-fail. Okay, so when they're asking you to do these exercises, and if you comply, or if your client complies and your client does them, it's not that traditional pass or fail, because that would basically put more reliability on it, and the district courts have said that it's not pass fail. So that's good. So you want to make sure that the police officers aren't using that language. These exercises must be done on a flat, well-lit surface, free and clear of debris. And one of the slides I'm going to show you in a few slides is one of the many examples that my firm has had where these exercises are not done on a flat, well-lit surface, free and clear of debris. So they're constantly violating their own rules and procedures. Now these, as Mehdi said, these exercises are non-testimonial, so the Miranda rights do not need to be read prior to the SFSEs. And there's 5 exercises that are generally used, and 3 are officially recognized by Nitsa. So what is Nitsa? Nitsa is the National Highway Traffic Safety Administration. They're the ones that, in conjunction with some other agencies, came up with these field sobriety exercises. They're the ones that have done some of the, or at least the studies that law enforcement relies on. However, in most cases, none of that's admissible in court. So you can't talk about for better or worse, meaning the prosecutors can't talk about how, the combination of these 3 is 91% reliable, and the defense attorneys can't talk about how, well, this exercise is only 66% reliable and this one's 72% reliable, and so on and so forth. All that information is in all of Nitsa's books and guidelines, but I think that's really not necessary for today's DUI practitioner, because most of the courts in Florida don't even let the attorneys get into that information and data. But out of the 5 that are generally used, 3 are officially recognized, so or standardized. So you're going to see those 3, you should, on every single DUI case. The first one is the horizontal gaze nystagmus, which is commonly referred to as just the follow the pen exercise. It's the eye test with the pen. The second one is the walk and turn. If you've ever seen the Reno 911 has done some great videos on that. You can go on YouTube and check them out. And the one leg stand. Now, the 4th and the 5th are, again, it depends on the officer, it depends on the jurisdiction, but a lot of times they're quite often used as well, and that's the finger to nose and the Romberg Balance. And I'll go into all 5 of them for you folks. One thing that's really, really, really important, and this also goes back to what Manny said earlier about the client interview, when you're trying to find out if your client has any injuries or illnesses or disabilities. And understand that injuries, illnesses, and disabilities are 3 separate and distinct things. They are not the same. But you want to find out from your client if they have any of those issues. And the police officers are supposed to be doing rule-out questions to rule out any possible issues to make it fair. But quite often they don't. And there are a bunch of seated exercises that are commonly, that are used. I guess I won't say commonly, because not everybody uses them, but there's about 3 or 4 that are trained. What you'll see is that most officers aren't trained in them, and sometimes there are officers that are trained in them, but for whatever reason, my opinion is they're lazy and they don't want to deviate to something that's not, their script, they'll rarely ever be used. And so that's great for cross-examination at trial. That's great for building your case to that point, or to using that at a deposition or a formal review hearing, and then using that again to negotiate with prosecutors for a reduced charge. So this is a case that we had, right? And this is a screenshot from a dash camera. This is a Florida Highway Patrol trooper in South Florida who used to be the main DUI person from Florida Highway Patrol in Broward County. He is no longer on the DUI unit because the prosecutors kicked him off the unit because he was so terrible. I can proudly say that we've never, ever lost a case that he was the arresting officer on. We've never had, and what I mean by that is we've never, ever had a client plead guilty or no contest to a DUI where he was the arresting officer. But when we look at this video, is that a flat, well-lit surface free and clear of debris? Well, it's lit. Okay, I'll give him that. It's not flat. It's not level. It's not free and clear of debris. And this case actually went to trial where the judge granted our motion for judgment of acquittal based on lack of impairment. And if you can see in this, there's puddles, okay? Which if there's puddles being formed, then the area is clearly not level because the water has to go somewhere. In this case, I know this is a screenshot, but in this case, it wasn't heavy rain, but there was light rain. You can see rain droplets in those puddles. The picture, our client's face is blurred out, but the police officer, his hand right now is actually on his face, wiping off a raindrop that's actively raining on him during these exercises. So sometimes these exercises are completely unfair. And this is just a recent example of that. So these are things that you want to be on the lookout for when you get a client, and they're doing the field sobriety exercises and you're reviewing this in discovery. You want to really carefully look at this. I've had cases where back in the day, I would go out and take my own ruler or / level. I went on Amazon and for $20 bought like a ruler level combo, and I'd go out there and take pictures myself. And there's nothing, right, when you look at something and you're like, kind of looks level, and then you put a level there and the little bubbles all the way to the side, and it's clearly not. Now, of course, the best way to do that is to have a private investigator go out there and do that, so that way the lawyer's not, doing it themselves for a whole host of reasons. And that's the way we handle things now. But 15 years ago, very early on in my career, I liked doing it and it was fun. And if I knew it was going to trial, then I would have our private investigator at that time do it again themselves. But now we just send them out to make it official from the start. So let's talk about the first exercise, the horizontal gaze nystagmus. Now, some DCAs in Florida allow police to talk about medical terms in nystagmus, others don't. Down here where we're at in Broward County, they do not let the police officers talk about that unless they are DRE certified, which is Drug Recognition Evaluator. Now, down here, what they do allow is the follow the pen exercise. So basically, they'll allow the officer to say that our client's eyes were not properly following the pen, or they were swaying, or they had balance issues during it, but they're not allowed to talk about nystagmus and the eye jerking and if what that means, and if they believe that corresponds to any accompanying breath alcohol level. That's not allowed down here. Some DCAs in Florida do allow a little more leeway than they do in Broward County. But for me, even when we have a DRE, I've always felt that stuff is above the jury's head, and there's some great materials that you can get to read on HGN. And when, of course, you want to do this in a deposition or a formal review hearing first, because you want to cross the officer on it and find out their real true level of knowledge on this, or are they just regurgitating what they read, in a workbook during a 20-hour, or a 40-hour 5-day course, right? Because of course, they're never going to be able to talk about HGN as an expert ophthalmologist would. So you might want to test that. One of the great resources is Duanes, D-U-A-N-E-S. It's actually a very popular medical journal or medical book specifically for ophthalmologists and optometrists, and that has a whole host of information about HGN. So if you want to learn more, I'd recommend reading Duanes. But for the most part, I don't think it's necessary. The second exercise is the walk and turn. Now let's look at this little picture that I have here. This isn't from one of our cases. I got this courtesy of of the internet. But is that is that line flat and level? Right? No, it's on the side of the road specifically for drainage, for water drainage. So even when they're doing it on the side of the road, a lot of times that's not a flat level surface. What they're going to do is they're going to have your client stand in the instructional stance. And one of the big things they're looking at is the client, whether the client starts early or not. And it takes a solid minute to give the instructions for the walk and turn. And after they do, and they tell you when to begin, it's going to be 9 steps forward, heel touching toe with your arms down by your side. They're going to want you to count out the steps. And then when you hit the turn, it's a series of small steps. So it's not a military about face. It's not a step off the line and start again. You have to keep your left foot planted because you should end on your left foot if you're doing it correctly. And while your left foot is planted, you're taking a series of small steps around with your right. And then you begin again and you go 9 steps back. That's the basic walk and turn. Of course, it's a lot more complicated than that. And in a few more slides, I'm going to go over an example of how I crossed a police officer on that in a trial, and it was very effective. The next exercise, the third of the 3 that are standardized, is the one-leg stand. Again, they're going to want you to stand in the instructional stance, and that's basically just going to be, feet together, arms down by your side. And when feet together, they're going to make you put your feet, together. With your knees together. And I know for some people that's even that alone is very hard to do. You're going to raise your legs 6 inches off the ground. You're going to keep your arms at your side, and you're going to count 1001, 1002, etc. until you get to, until you get 30 seconds. And they're going to time you for 30 seconds. And you should get to 1030 at that time. But most people don't. Things that they're looking for in this, they're looking for, are you raising your hands? Do you have any balance issues? Are you hopping on one foot? Do you put your foot down? And so those are the things that they're looking for. And these officers, they have their own checklists. So they're sitting there literally just checking off boxes. Of course, they'll never say what you did well. They'll only check off the things that you did poorly. Now, the finger to nose is one, again, that we talked about that's not Nitsa approved. And here's a picture of the old school way to do it. They used to have you do it with your arms out. And as of about 3-4 years ago, they want you to keep your arms down by your side and bring them up directly. But there is that same instructional stance as the one-leg stand. Your arm, okay. And on the old school version, they're going to want your arms out, your index fingers pointing out, close your eyes and tilt your head back. They're looking for balance issues. They're looking for coordination. A lot of these officers will have a literal nose on their sheet, and they're going to be marking the exact part of the nose that you touched. And one of the ways that they really try to trick people is they say the tip of your finger to the tip of your nose. And when you do, if you can see right here, when you do that, that's actually incorrect. Because what that is the finger pad. And the way they demonstrate is with the fingertip. So the way they demonstrate is this way. And we've had clients do this perfectly, except they use the pad and not the tip. And officers have said, I'm sorry, I'm making the arrest. And now that's ridiculous. Those cases are great for trial, are great, for negotiating with prosecutors. But unfortunately, that's what they're looking for, and that's how particular they are on these exercises. And it's really unfortunate for people that are, maybe had a drink or two, like we talked about earlier, like Mehdi talked about earlier, where you're allowed to consume alcohol. You just can't be impaired or over the legal limit at the time you're driving. And somebody has, one drink and they do that and they're off by doing this instead of this. To me, it's kind of that, it's really petty, and it's kind of, like, ha, gotcha type of thing, which, that's why we do what we do. We fight against those things. And the last one is the Romberg Balance, which is just stand together, feet together, arms by your side, close your eyes, tilt your head back, and estimate 30 seconds. I think the cases where you're estimating 30 seconds in 15 or 45 or 60, obviously that's a little worse than 25 or 33 seconds. But really, they're looking for eyelid tremors, they're looking for balance issues, and they're looking for not being able to effectively, grossly miscalculating time in that situation. So I talked a little bit about, depositions and Bureau of Administrative Review hearings, and I wanted to give you guys just a few good questions to ask, right? Because if one of the themes on this case, especially if it's your client's first DUI, you can weave that in there in a little bit of a sneaky way, right? And basically, you want to ask the officer, how many times did it take for them to practice the SFSEs before they could do it perfectly, right? Because really, in their mind, they are seeking perfection, and you want a jury to understand that, hey, wait a minute, this is a setup. Nobody can do perfection, and that it's not fair to people. Obviously, you can talk to them about the training and the classes they undergo and how they're doing them, and they're doing them multiple times to practice. Okay, and you really want to focus as well on all of the normal actions that your client did and what they did correctly, such as how they pulled the car over after the lights were activated. Obviously, if that's on video and they pull over quickly, I love it when we can calculate that within 1 or 2 seconds, our client's brake lights turn on, right? That's gold. Because if we're going to be talking about divided attention, which is what these exercises, these abnormal things are designed to measure, why don't we measure the divided attention that is normal instead, such as looking in the rear view, eyes see blue lights. Blue lights from your eyes tell your brain that you're being stopped, which tells your foot to go from the gas to the brake, which tells your hands to slow down and then slowly and carefully pull the wheel over, right? That's divided attention, but those are normal divided attention tasks instead of these abnormal things that people don't do, that people need to learn how to do. So those, I really like that line of questioning. Obviously, if your client walks out of the car or gets out of the car normally, walks over to the area normally, and that's on a body camera or an in-dash camera, then you want to use those things. Anything that your client did well, you want to exploit and really focus on. Because again, if it's a normal thing that your client's normal faculties are doing, then to me, that's a lot more reliable than these abnormal things. Back to what we said earlier, the officers often confuse average with normal, and these are, they're not they make them one size fits all, but that's not the way that they're supposed to be, and we shouldn't accept that, right? And there's a difference between if your performance is prevented versus affected. So a lot of times they'll ask you, do you have any injuries that would prevent you from doing these simple little tasks? Well, if your foot's amputated, you're prevented from doing the walk and turn, right? But if you have a bad ankle or a torn ACL, right, or some other injuries, then your performance is affected. And the words that the police officers use matter, but they never use it in those words. So somebody might say, yeah, sure, there's nothing wrong that would prevent me. And then they're not thinking about, well, yeah, I have that ACL that would affect my ability or hamper or diminish my ability. And again, seated exercises are rarely used but available, and it's a great point for cross-examination. So what are some examples of these normal faculties, right? We went over them, of course, from what the statute said, but speech. We all, and these are things that you, to the extent that the judge will let you, you want to get into this as much as possible in jury selection. And I know David next is going to talk about trial and jury selection. But you want to, my personal belief is you want to push that limit. You want to go until a judge says you can't. That's just, my belief. But of course, everybody else can have their own way of doing things. But speech, we don't all talk the same. Some people have accents, some people mumble. Some people mispronounce words while under stress, right? Walk and balance. We don't all walk the same. Injuries, age, weight are factors. For the women that wear high heels, right? That's obviously going to be very difficult. Men or women wearing dress shoes, that's difficult. We all can't wear military boots or, basketball shoes with, perfect support and protection to do these exercises. Of course, we couldn't argue that footwear issues in the case in that screenshot I showed you earlier, because that client was wearing basketball shoes and did have really good support and protection. But luckily, the location that the trooper chose was so terrible that it didn't matter. Right? Mental faculties. How do we learn? Some of us are visual learners. Some of us are tactile learners. We need to practice. Some of us are quicker learners than others. And what about how we act in emergencies? We have those people that are very stoic and calm, and then we have the nervous Nellies. And so it's really important to understand the difference in people and how they oftentimes confuse average with normal. Now, here's an example from a case. This is a walk and turn, and this was done on video by a police officer in a trial that I had. And she basically sped through rapid fire these instructions for the walk and turn. And what I did was I broke them down into each and every separate instruction. Okay. And when I did that, I got her to admit that she gave our client 17 different instructions, while of course he was standing in that instructional stance, which the walk and turn is, you have to stand heel to toe with your arms down by your side and balance for a minute. And then he actually got 14 out of the 17 correct. And it was a bit slow, a bit methodical, but I really wanted to hammer home that point that this is somebody who's never done these before, has never practiced, got rapid fire questions, or instructions from an officer under a stressful situation. And yet he did 14 out of 17 correctly. And it went really well. It went over very well with the jury. It was a very effective cross-examination. So you folks can do that too and break it down into the numbers. I feel like when you question on how many specific instructions and how complicated these are, that really resonates well with the jury. Now, I've heard many lectures on DUI where the lecturers have said they don't want people who are used to judging others. And generally I agree. However, if your theme is going to be client's first time ever doing these and attacking the exercises as complicated and too hard and no room for error, then I in those situations like teachers, coaches, and office managers, because yes, they can be a little judgy, authoritative figures, but they have experience with people who are learning. And they have experience knowing, oh, geez, Bob, you need to tell Bob 10 times before Bob really gets it. Of course, and right, we can't just tell Bob or show Bob once and he's gonna, he's never gonna get it right. He needs some time. So if that's gonna be your theme, which in some cases it is, in some cases it's not, or not just the theme, a big part of the case, then me personally, I do like some of those professionals on my jury. But those are things for you to, of course, flesh out in voir dire, and I know David will go over more in more detail that. Especially if the impairment looks slight or moderate. If somebody's fallen all over the place, then you might have it might go to trial, it might not, but you may have different arguments. This is the end of the field sobriety portion. We're going to talk about the breathalyzer. We're going to talk about urine testing and a little bit about blood testing as well. So first of all, as we're talking about the breathalyzer, in Florida right now, we use the intoxilyzer 8000. And one of the things that I tell all of our clients, every time we lecture is and to lawyers as well, do not be afraid of a high breath test. We hear it so often, well, I blew high, I blew over, my lawyer told me there's nothing that can be done. And that's just simply not true. Of course, there's so many motions to suppress that can, invalidate a breath test, or if, as what Mehdi talked about earlier, if the stop's bad, then it doesn't matter if the client had a 4.0 breath. It doesn't matter if the client had 10 kilos of cocaine. Stop's bad. Everything else that comes from it is bad, as we all know from law school. But don't be afraid of a high breath test. High breath tests can be won. You just have to attack, the breathalyzer. The intoxilyzer 8000, that's what's currently used. Now, it was first manufactured by CMI in 2001, and it was finally approved and used in Florida in 2006. So if you think about that, this machine, computer, whatever, they call it an instrument, because I personally don't know why. I guess it sounds fancy. But this machine, it's older than smartphones. Okay? Back then, we all had our Motorola Razr or our Nokia phone, right? Okay, if you folks remember that. Windows, we were on Windows Vista. Okay? So when you talk in terms like that, those are things that jurors can wrap their head around. Everybody who's, right, who was around then remembers Windows Vista and how clunky it was. They remember the Motorola Razr flip phone and the Nokia phones. And to us now, that seems as ancient technology. So even though it's only been 15 years, it's been ancient technology. And the actual technology behind it is infrared radiation technology from decades ago. So as we break down the breathalyzer, the picture on the right is the intoxilyzer 8000. And as you can see up at the top, there's a handle on it, which I'll talk a little bit about later. On the left, right, this is a great picture of some wacky invention, one of the precursors to the breathalyzer back 40, 50, 60 years ago. And really, I don't think much has really changed between the picture on the left versus the picture on the right. So as we break this down, we're going to focus on just a few of the common areas of unreliability because, we could go real deep over 4 or 5 hours on this stuff alone, but I want to give a few of the most common areas of unreliability with this machine. And it all does boil down to junk science. So we're going to talk about breath temperature. We're going to talk about partition ratio. We're going to talk about margins of error, time of driving, the 020 agreement that Mehdi also briefly discussed, and source code issues with the actual, machine and how it does its calculations. So let's start talking about breath temperature errors and issues with it. And what I said before about them confusing average with normal is the exact same with this quote unquote science part to it. They're confusing average with normal. Okay. If you've ever heard the phrase garbage in, garbage out, right? Or you're only as good, especially for the mathematicians here, you're only as good as your equation, right? It's the same stuff. So what they do is they will estimate your breath temperature at 34 degrees Celsius, which is 93.2 degrees Fahrenheit. A higher breath temperature will yield a false positive or an increase in what your breath alcohol content, higher, it'll measure higher than what it really is. A lower breath temperature will actually decrease the BAC. And there was a study from 1995 where they had 700 subjects and found that breath temperatures actually ranged from 33 to 36.7, and the study recommended a 35 degrees Celsius instead of 34 average, which is statistically significant. And if that is true, and if that is a safer, more conservative average, then the intoxilyzer 8000 is overestimating, the vast majority of the breath tests that are conducted with it. Okay. And the technology is not there to actually measure that breath temperature. So they have to do all of these calculations, and it's wrong. So when if you have officers or breath techs that understand this, right, then they should give you some concessions. If they don't understand it, then you can really rip them apart and just have some fun going after them on this stuff. But again, of course, we recommend you want to know the people in your local jurisdiction and how they're going to answer these questions. So you want to get in the habit of doing these formal review hearings, and if you can, take depositions on these cases. The second thing that I want to discuss is partition ratio. And it's derived from Henry's Law. You can Google Henry's Law. I don't think it's that important for what we're discussing, to go too deep into that. But more or less, it's the conversion. Henry's Law is a little different, but the partition ratio is the conversion from breath to blood levels. Okay, and of course, it assumes a closed system at 34 degrees Celsius. So that's why I started with breath temperature first and foremost, because even partition ratio, makes a variety of assumptions. Okay, the partition ratio that the intoxilyzer 8000 uses is 2100 to 1. But in studies, they've shown that partition ratios in human beings vary from 900 to 1 to about 3400 to 1. And there was a study from 1983 that said that the correct partition ratio should be 1756 to 1. And if true, again, it means that the intoxilyzer 8000 is overestimating breath tests, because people that have a lower partition ratio are having a higher reading on the breath test than what is actually in their body or in their blood. And that's another example of false positives. Okay, where and when you combine multiples of these false positives, you can see that somebody may actually have a blood alcohol level of 0.6 and yet they're blowing an 0.9 or a 1.0, and it is significant. We're not talking about just a few numbers here. Now, the thing about the closed system, right, and I'm going to talk about this a little bit actually next. Our bodies, what's going from our body into that machine is not a closed system. It's not under perfect ideal conditions like their own testing is. They test these machines every month. They have simulators, right? And these simulators have, they're basically solutions that have the specific amount of, the exact amount of ethanol in these solutions. And yet, even these, when they do the testing, there's a margin of error. So let me go into that next. So this is a picture, right, of one of the monthly inspections that they do, and they have to submit to FDLE. The great news is that all of this data is available on FDLE's website, and I think in the next few slides later, I'll have that information for you. But when they are doing these tests, they do 3 tests, an 0.5, an 0.8, and a 0.20. And they have acceptable ranges on these tests. So in order for a test or a machine to fail inspection, it has to be on an 0.5 test below 0.45 or above 0.55. So there's basically a 10-point swing that's allowed, right, on these. On the 0.5 and the 0.8 and the 2.0 test, there's a 20-point swing that's allowed. And yet this is perfect, ideal conditions. There's not going to be anything more accurate than a tested and inspected solution that has the exact amount of ethanol in it in an actual closed system, meaning not a human being's body that has to deal with temperature issues, that has to deal with, are you sick, are you not, that has to deal with how much breath volume, how hard and deep do you blow into the machine, that doesn't have to deal with, do you have dental work, did you burp, regurgitate, are you coughing, do you have acid reflux or GERD, right? All of those things that can potentially be issues with us as human beings, you don't have in a closed laboratory style testing, and yet they get a higher margin of error than what we get. Right? It doesn't make sense at all. And these are things that when you do, if you do go to trial on a breath test, you should be cross-examining them. And of course, like I've said many times, you want to know how these people, these breath test agency inspectors are going to react and answer those questions that you ask. So the picture on the right, it's a scale. It's a broken scale. The O2O agreement. So if you give two breath samples and one is an 079 and the other, the second, is an 098, both are valid samples under the law because they're within 0.020 of each other. If one of the great things that I like to do, and it's not unique to me or to us, right? It's common, but if you can get away with it in voir dire, fantastic. If you do it, if you save it for close, that's great too. But if you got on a scale and it said 079 or 79 pounds, and then you got back on the scale and it said 98, there's no way that scale is accurate. We're throwing it out. We're buying a new one. It's garbage. And yet these prosecutors and these police officers want you to believe that machine is accurate. It just does not fly. One of the other things that you can easily cross-examine on that leads to unreliability is time of driving. Now, some of the jurisdictions have handled this in a little bit of a better way recently, but when they bring you back down to the BAT facility, to the breath alcohol testing facility or in your jurisdiction, there's usually between an hour and 2 hours after the time of driving from when your client gives that breath test. Now, sometimes now they're bringing the intoxilyzer 8000 on scene. They're putting them in SUVs. I know Mehdi talked a little bit about that a little earlier, how one particular officer that we've been dealing with says he doesn't bring his out because of radio frequency RF interference. But it is portable. So if you have a breath test and it's given an hour and a half, 2 hours later, right, you can really cross-examine the officers and the breath techs about the portability of this machine, because when they're doing DUI saturation patrols and they're doing DUI checkpoints, they do bring them out with their mobile units, right? So it's, this machine, it's a little bigger than a laptop, right, opened, but it's portable. It has a handle, it has batteries, it has an AC adapter. You just bring it and you plug it in, right? So it's not our job as defense lawyers to prove what the breath alcohol level was at the time of driving, or to prove that it wasn't a 0.08. Remember, it's the prosecutor's job to prove that our client was over 0.08 at the time they were driving. And alcohol is absorbed and eliminated on a bell curve, right? And so, it's the prosecutor's job to prove whether you were absorbing or eliminating alcohol, and they can't do that. It's very hard for them to do retrograde extrapolation. I don't want to get too much involved in that stuff, but for today, but it's very hard, and they're not going to be able to do it. And the last thing is CMI, the manufacturer of the breath test, their trade secrets. So their source code. They've never divulged the source code. They've spent hundreds of thousands, if not millions of dollars defending and preventing the source codes from being disclosed to defense attorneys in every single state in which they have contracts with. So you can't go under the hood of this machine. No police officer in Florida has ever opened up the intoxilyzer 8000 while they've been a police officer, because if they did, they would be fired and FDLE would lose their contract. So ask these breath tests if they've ever, quote unquote, gone under the hood, right? And from a kind of another practice, trial standpoint, I like having, if this is going to be part of your defense, you may want a mechanic on your jury, somebody who is handy, somebody who can directly relate if you're going to use that, you didn't go under the hood of this machine, so you've never inspected it. You don't even know what's inside of it, do you? It's a bunch of tubes and wires and microchips, right? Maybe a computer repair person, anybody who knows that, no, wait a minute, machines and technology break and sometimes are wrong, you got to open it up and you got to take a look and you got to fix it. So this argument can go really well with people like that, if that is going to be your theme, So that's important. Now, these are some screenshots here. First of all, on the left, we have the link, and FDLE has kind of made it harder and harder to find the breath alcohol testing records on FDLE's website. So just use that direct link, because it's very difficult now to find on the homepage of FDLE when it used to be very easy to find, of course, right? Surprise, not really. But these screenshots just show some different examples of the immense data that you can get from FDLE's website about these breathalyzers. And you have to go through these. You have to go through these on every single case. Sometimes there's a bit of a backlog, so if your client gets arrested yesterday and hires you tomorrow, it's not going to be available right away. It may take a few months, but that your judges push you to trial in 90 days on a DUI, because especially on a breath case, because you got to do the work. And how can you effectively represent somebody if you're not looking at these records? The maintenance records, right? And the more the subject test data records, which the one on the bottom left is going to, actually, I'm sorry, it's not the one on the bottom left. That's an inspection. But when you look at your client's specific breath test, the computer printout that the police get, that the prosecutors use, is basically a summary version, and there's more details at the FDLE page that they have to upload to FDLE. So this stuff is really invaluable for your cases. You really want to be on that. Here's a quote from a judge in Orange County. It's a Florida Law Weekly case from 8 years ago, but this is great. And this quote was actually quoted in the New York Times about 2 years ago. There was a fantastic article in the New York Times about how breathalyzers across the country are unreliable and have led to false convictions. So I highly recommend you read that article. But the Intoxilyzer 8000 is a magic black box assisting the prosecution in convicting citizens of DUI. The defendant is required to blow into the box. The defense has shown significant and continued anomalies in the operation of the Intoxilyzer 8000's operation. The prosecution argues most of the tests do not show anomalies. In fact, a high percentage of the tests may show no anomalous operation. That the Intoxilyzer 8000 mostly works as an insufficient response when a citizen's liberty is at risk. That's powerful. That's an extremely powerful quote. So if you are going to be filing motions to suppress on these issues, that's a fantastic quote to put. And it's just, it's really powerful statement just to add in there. Of course, that's not really necessarily a legal basis, but when you're making these arguments, the fact that a judge said that is very powerful, I believe. What I want to do next is go over urine and blood samples. Very brief, overview. So urine, we're going to see this more and more on drug DUI cases, especially now, that the police aren't making marijuana really related arrests in our state, very much at all. We're going to see a huge increase in DUID or DUI drug cases, and the states where marijuana is, recreationally legal, they've had a tremendous spike in DUI drug cases. But understand, urine is nothing more than a waste byproduct of what was once in your blood, or AKA in your body. Think about urine in your bladder like a Ziploc bag that just happens to be inside of you, but it's not really a part of you or affecting you. And that's the way, that I want people to consider this, and I want our jurors to consider this, right? Your urine is in your bladder. Yes, it's inside of you, it's a part of you, but it's not really, because it's just a holding tank waiting to be expelled. And urine testing is extremely unreliable for drug DUI cases. It's very difficult for their experts, the state experts, to extrapolate back to time of driving. And any good, legitimate forensic scientist will put no weight at all in a urine result for a DUI case. All it says is that at some point a person used a substance. It doesn't say when, doesn't say how much. It doesn't say how they used that substance, such as Was it, if it was, we're talking prescription medication, was it used as prescribed? They won't and should not be able to give an opinion on whether the drugs found in your client's system were therapeutic or impairing, right? And that's a big distinction, because there's no legal limit for drugs in a DUI case. And you have to combat a little bit of the stigma that people have when we're talking, especially about illegal drugs, right? Heroin, cocaine, still marijuana, but even prescription drugs, because people, I've found, will default to, oh, well, you can have a drink or two at dinner and drive home, that's okay. But you obviously, if you have cocaine in your system, that's terrible, that's illegal. But even if you have Vicodin or oxycodone or Soma or Xanax in your system, right, without being able to understand that for the vast majority of people that take that, there are therapeutic non-impairing levels, right? And there is no per se legal limit. So again, it goes back on the prosecution to prove that you were impaired by that. Okay, and that's a huge distinction. And take depositions of these toxicologists, the medical examiners, whoever's doing that. I believe even in the jurisdictions that don't like giving depositions, when you have a urine case and they list an expert witness, that is good cause to take that expert's deposition. And I believe you should be ordering the transcripts and saving the transcripts and creating a transcript bank of what witnesses are going to say, so you have that throughout all of your cases. Finally, we're going to talk a little bit about blood. You'll see it in the following circumstances: really, DUI, manslaughter, vehicular homicide, serious bodily injury, or if a breath test is impossible or impracticable. For today, that's really all I really want to discuss specifically about blood, besides going into the medical records investigative subpoenas. That, I think, is really important to go over for the new practitioner. Okay, and so medical records investigative subpoenas, it could be urine, it could be blood, right? Usually we're talking fire rescue and we're talking medical records. Okay, well, medical records could be fire rescue or it could be at the hospital. The state must serve you a notice of intent to serve a subpoena ducis tecum. You have 10 days to object. Always object. Even if you know that we're going to lose, or you're going to lose. And the majority of the time you lose these. You have to object. Make the prosecutors do their job. Make them set a Hunter hearing, which comes from State v. Hunter, which is basically a hearing on, of whether or not your client's medical privacy interests are greater than the state's, interest in getting this information to prosecute a crime. We've prevented medical records on cases after a Hunter hearing was granted, just by objecting because a state forgot to set a Hunter hearing. So we've had cases where we filed our timely objection, and then 7 months later, we're ready to, prepare the case for trial or file a motion to suppress, and they forgot about it. It happens a little bit more in the jurisdictions that are larger and the prosecutors are, drowning in cases, but you got to make them do their job, right? So that's something that I think, has really helped us in some cases. At the Hunter hearing, the state must prove a nexus between the information sought and the crime alleged to overcome the defendant's medical privacy rights. And again, most of the time you're going to lose. It's very easy for them to prove that nexus, but we force them to do their job. We've had other cases where prosecutors have received the records and then they never file a supplemental discovery, and then they were barred from using them at trial or at a motion. And what I like to do is I like to request that the judge review the records in camera prior to distribution to the prosecutors and defense. So I like it when the judges say, I'm going to sign the subpoena ducis tecum, but it's coming to me, not coming to you, state. And again, we've had some cases where the judge never received it and there was no follow-up at all. So make them jump through as many hoops as possible when you're doing, when you're defending against these medical records investigative subpoenas. It's all about maximizing your client's chance to win this case. Hopefully, this kind of surface level overview really helps you folks. Of course, we have our QR code. you can call us, me or anybody from my firm at any time. We love talking this stuff. We love helping out, and hopefully we can even do an advanced one sometime. That's all I got for you guys. Thank you very much.